Welcome to the Deep Dive. This is our study hall segment, Bills on the Hill.
Where we really try to unpack specific legislation.
Exactly. We look at the potential real-world effects, pulling insights, directly from the source material you give us. Today, we've got a stack of documents, and we're diving into some recent changes to U.S. immigration fees.
Specifically, Title VII, Subtitle A, Part 1 of a particular bill, right?
That's the one. Our mission here is to unpack what these sources tell us about this fee structure. What's its purpose? What are the reported impacts?
Yeah, it looks complex. Who pays, where the money goes, how it changes.
It does. So let's try and break it down.
Okay.
So digging into these documents, where do we start? What kinds of fees are we actually talking about here under this part of the bill?
Well, the sources describe a range of new fees, or fees that have been adjusted pretty significantly.
Okay.
And they're not presented as just, like, minor administrative charges.
Yeah.
The documents really emphasize this can be substantial amounts.
Substantial. Can you give us some examples from the text? What stands out?
Sure. For instance, there's a fee mentioned for filing an initial asylum application.
Sure.
The sources state it's set at not less than $1,000, starting in fiscal year 2025.
$1,000 just to apply for asylum initially.
Wow. And on top of that, there's something called a yearly asylum fee.
Yearly.
Yeah, not less than $100. And it's imposed each calendar year that an asylum application is still pending, still waiting for a decision.
So you pay while you wait. That adds up.
It certainly could. Then you've got fees for initial employment authorization, documents, EADs.
Right. Work permits.
For certain categories like asylum applicants, parolees, people with TPS, temporary protected status. Those are listed at not less than $550.
Okay. $550 for the initial EAD in those cases. Are there court-related fees too? Immigration court.
Oh, yes. The sources detail several significant fees for applications and motions filed within the immigration courts. That's the Executive Office for Immigration Review, EOIR.
Like what kind of things?
Things like applying for adjustment of status that's listed at not less than $1,500. Waivers of inadmissibility, not less than $1,050.
These are big numbers.
TPS applications filed in court, not less than $500. Appeals from decisions, not less than $900. Even older forms of relief like suspension of deportation or cancellation of removal, those are listed at not less than $600 each.
Okay, so clearly not small change. But there's a really key point the sources seem to hammer home about these fees, isn't there? Something about waivers.
Yes, absolutely critical. The documents state that many of these fees shall not be waived or reduced.
Not waived or reduced. Which one specifically?
Well, the initial asylum fee, that yearly asylum fee, most of those EAD fees we mentioned for asylum seekers, parolees, TPS holders, and the bulk of those EOIR court fees.
So no arguing you can't afford it.
Essentially, yes. The sources say there are no provisions for waivers or reduction based on, financial hardship or ability to pay for these specific fees.
Are there any exceptions mentioned?
A few, very limited ones. The sources note things like parole based on specific medical or law enforcement emergencies, or maybe court continuances for exceptional circumstances. But they emphasize these are not broad financial hardship waivers.
So not the kind of waiver someone could get just because they don't have the money.
Exactly. That's how the sources frame it.
So putting this together, high fees, no financial waivers, what picture do these documents paint about the impact on people trying to use these legal paths?
The picture painted is one of significant financial barriers. The sources suggest that for people with low income, the inability to pay these non-waivable fees can effectively block their access.
Regardless of the merits of their case.
That's the implication described. That financial inability becomes sort of a de facto obstacle. It raises, as the sources frame it, a real question about cost versus access to legal processes in the system.
Which leads us to the next big question. Where does all this money actually go? The sources describe a pretty complex allocation system, right? It's not all just covering processing costs.
No, definitely not just covering costs. It's complicated. Some fees do have portions directed back to the agencies doing the work.
For example?
Like sources mentioned, 50% of that initial asylum fee goes to the agency that handles the case, whether that's EOIR or USCIS.
Okay.
And 25% of the initial asylum EAD fee goes to USCIS. With half of that amount, so 12.5% of the total fee, specifically earmarked for fraud prevention within that specific EAD process.
So some specific allocations.
Yeah, and there are mentions of other fees potentially partially funding things like care for unaccompanied alien children, that's HHS, or border processing by CBP, anti-fraud stuff at the State Department, Or certain ICE operations may be linked to diversity visas, but that's only part of it.
Only part. Because the sources consistently point somewhere else for a lot of this revenue, right?
Exactly. A substantial portion, and often the entirety of many of these fees is credited differently, is classified as offsetting receipts.
Offsetting receipts, what does that mean in practice?
It means the money is deposited directly into the general fund of the U.S. Treasury.
The general fund, so like the government's main pot of money, not tied to immigration processing specifically.
Precisely. It goes into the overall budget pool that Congress appropriates for all kinds of government spending.
Which fees, according to these sources, are the ones mostly feeding this general fund?
Well, besides the remaining amounts from those partial allocations we just talked about,
Right.
the sources explicitly state that 100% of fees, like the initial and renewal EAD fees for parolees and TPS applicants, go to the general fund. Also, the parole fee itself, the special immigrant juvenile fee, that yearly asylum fee we mentioned.
The $100 a year one.
That one. And most of the revenue from the EOIR court fees that isn't specifically given back to EOIR, it all goes to the general fund.
And the sources also mention some hefty fees linked to enforcement situations.
Yes, very high ones. Fees listed as not less than $5,000.
$5,000 for what?
For things like sponsors of unaccompanied children who don't show up for court, or people ordered removed in absentia, meaning they weren't at their hearing, or certain inadmissible individuals apprehended between ports of entry. Those also go to the general fund, according to the documents.
So when you see this broad channeling of funds into the general treasury, what do the sources suggest is the main legislative goal here? Is it just cost recovery?
The strong implication presented in these sources is that general revenue generation for the government as a whole is a primary objective for collecting many of these fees, going beyond just covering the costs of the specific service.
Okay, and then there's the connection to how that general fund money gets spent. The sources talk about large appropriations from that fund for immigration enforcement, right?
Yes, this is a connection the documents explicitly draw. They detail billions being allocated from the general fund pool for a range of enforcement, detention, and removal activities.
Like what specifically?
Things like $1.25 billion for hiring more immigration judges and support staff, a massive $45 billion allocated for expanding adult alien detention capacity.
$45 billion.
That's what the sources state. Also, over $9.4 billion combined for hiring and retaining ICE personnel, $14.4 billion for transportation and removal operations, and almost $800 million for state and local support for enforcement activities.
So the narrative these sources are building is revenue collected, partly from people seeking benefits like asylum or work permits, ends up contributing to the funding pool for the very system that includes large-scale enforcement, detention, and removal.
That's the complex dynamic described in these documents.
Yeah.
The fees acting as potential barriers while also contributing revenue to the broader enforcement apparatus.
Okay, let's shift gears slightly. How are these fees designed to change over time? The sources mention something starting in fiscal year 2026.
Yes, an adjustment mechanism. The documents specify that starting in FY 2026, and then every year after that, most of these fees will be adjusted based on inflation.
Inflation? How do they calculate that?
They use the Consumer Price Index, the CPI, specifically the CPIU, which is for urban consumers.
Okay.
The calculation described is, you take the fee amount from the previous year, and you increase it by the percentage change in the CPIU from the July before that to the current July.
Sounds a bit technical.
It is, and there are specific rounding rules mentioned too, usually rounding down to the nearest $10, though some smaller fees like that yearly asylum fee might round down to the nearest $1.
And the rationale for this, according to the sources, why tie them to inflation?
The stated purpose, as described, is to make sure the revenue generated keeps its real value over time, to prevent inflation from eroding the purchasing power of these fees for funding government operations.
Including enforcement.
Including enforcement, yes.
But just like the initial fee levels and the lack of waivers, the sources also talk about the impact of this annual increase on the people applying, right?
They absolutely do. The argument presented is that by automatically increasing these already high non-waivable fees every year, this CPI adjustment will likely maintain or even increase the financial barrier for low-income applicants over time.
So it could get progressively harder to afford.
That's what the sources project. They suggest the yearly increases will probably make the fees even less accessible for people who have limited money.
So this annual adjustment isn't just a technical budget thing. As the sources describe it, it actively reinforces and potentially escalates that financial obstacle we talked about earlier.
That's precisely the impact highlighted in the material, yes. It potentially solidifies cost as a barrier to navigating the legal system.
Okay, so let's try and pull this all together. What these documents do give us is a really detailed snapshot of this specific set of immigration fees under Title VII, Subtitle A, Part 1.
Yeah, they lay out the amounts. They really stress the lack of financial waivers.
That shall not be waived or reduced part.
Exactly. They detail where the money goes, some to agencies, but a lot to the general treasury, which in turn funds significant enforcement budgets. And they describe how these fees will automatically increase with inflation every year.
And the sources consistently highlight the practical effect of all this.
Yes, they frame these fees as significant financial hurdles, as deterrents, particularly for people without much money, limiting access to legal pathways that exist on paper, regardless of eligibility, simply because of the cost.
Or creating that tension you mentioned.
Right, the tension between having a legal process and making it financially inaccessible for some. That's a central theme in how these sources describe the situation.
Now, equally important for this deep dive is being clear about what these specific sources don't cover. What are the boundaries here?
Good point. The sources we looked at, they describe the policy and its effects in detail, but they do not get into potential legal challenges against this no-waiver fee policy.
So no discussion of whether it's legally sound or vulnerable.
No, they don't analyze that. They focus on describing the policy as written and its reported practical impact.
And they also don't give us wider context, historically or internationally.
Correct. These documents do not provide background on, say, historical uses of economic barriers in immigration control, whether in the U.S. or elsewhere.
No comparisons to other country systems either.
Nope. No comparisons to how other countries handle immigration fees or policies. Our deep dive here is strictly limited to the information presented in these particular sources about this specific U.S. fee structure under this part of the bill.
Okay, so this dives into Title VII, Subtitle A, Part 1 immigration fees, based purely on the sources provided, paints a picture of a system designed for, well, dual purposes, it seems.
It does. Partial funding for the agencies doing the processing, sure, but also significant generation of general revenue for the government.
With that built-in mechanism to make sure the fees keep pace with inflation year after year.
Right. And at the same time, as consistently presented in these documents, these fees, because of the amounts and the fact they generally can't be waived, function as pretty substantial and potentially growing financial obstacles.
Obstacles that the sources say can limit access to legal pathways based purely on someone's economic status.
That's the crux of the impact described.
It really does leave you with a provocative thought, doesn't it? Based entirely on what these sources lay out. How does a legal system balance its operational costs, its revenue generation goals, maybe especially when that revenue helps fund enforcement?
Right.
With the principle of equitable access. Access to legal protections, legal pathways, especially when the sources describe the costs as being set up in a way that could be insurmountable for those with limited means.
It's a complex equation presented very starkly in these documents.
Yeah.
Definitely something to consider as you continue your own learning journey on these topics.